New Mexico Real Estate Basics, page 37. What is negligence? Misrepresentation or omission of pertinent facts does not have to be intentional to bring liability exposure. Negligence occurs when brokers should have known that incorrect statements were being relied on as a material fact. Who is permitted to draw up contracts for the purchase or lease of real estate? New Mexico does not have any statutory guidance. While there is no law, the accepted standard is from a statement of principles document prepared by the Realtors Association of New Mexico and the State Bar of New Mexico. Essentially, brokers are not permitted to draft contracts, but rather to use pre-printed contracts by filling in blanks. Attorneys must prepare these contracts. New Mexico does not have NMREC promulgated forms. Most of the contracts used for residential and vacant land transactions are published by realtor organizations or are prepared by attorneys. What specifically may a broker not prepare? In New Mexico, real estate brokers should be cautious to avoid the charge of practicing law without a license. Specifically, a broker may not create estates in remainder or leases for periods greater than 10 years. Brokers are not allowed to prepare legal documents. Licensed attorneys must prepare these documents. A broker may fill in the blanks on forms prepared by attorneys. How is real property described in New Mexico legal documents? Land may be described using metes and bounds, lot and block, the U.S. rectangular survey system, and/or the New Mexico coordinate system. The New Mexico coordinate system is a method of determining the point of beginning for a described parcel of real estate. The system uses a reference to an X/Y coordinate grid. If there is any conflict between the New Mexico and U.S. systems, the U.S. system prevails. Is a legal description required in a listing agreement? New Mexico does not specifically address this issue. However, there must be a meeting of the minds to make a contract, and the street address must be definitive enough to clarify what is being purchased. Street addresses are not generally considered legal descriptions because of their temporary nature. A street address in a listing agreement may be sufficient to locate the property, but not to describe its boundaries. It is best that the legal description appear in an offer to purchase, but be sure of a legally binding contract. What forms must be completed during a real estate transaction? In addition to the purchase agreement, New Mexico requires the use only of the broker duties disclosure form by brokers. Property condition disclosures are not required in New Mexico. However, a copy must be given to the purchaser if the Page 38. Seller has previously completed one. If the residence was built prior to 1978. The seller and buyer must sign a lead-based paint disclosure form. NMREC rules require that every broker deliver to the seller a complete detailed closing statement and at the same time a detailed closing statement to the buyer. The broker must retain copies of these closing statements for 3 years after the date of closing, along with a copy of the listing, any offers to purchase, and all pertinent correspondence. Residential property seller disclosure statement. What is the purpose of a property seller disclosure statement? Although seller disclosure forms are not required by law to be used in New Mexico, realtor organizations publish a number of property condition disclosure forms for different types of property. The purpose of any property disclosure statement is to forewarn prospective buyers of the condition of the property before they write an offer. If the property is not as described, then the buyer may have grounds to revoke the offer. The disclosure statement includes information about the property's plumbing, electrical and heating systems, any significant structural defects, presence of pests, zoning classification, and whether the property is in a real estate improvement district. When must the property disclosure be made? When a disclosure is requested, it is usually a contingency in the purchase offer. Sellers and brokers should use great care to ensure delivery of current and accurate information. Sellers, not brokers, should always make this disclosure. How should these changes be handled if some items change after the seller filled out a property disclosure form? Once the form is delivered, any new discoveries, like a previous termite infestation, require an amended statement. If any items on the disclosure change during the escrow period, the form should be updated and delivered to the purchaser. Offers and acceptances. Does the listing broker have to let the buyer's broker present the offer to the seller-client? Listing brokers are not required to permit a buyer's broker to be present when presenting offers or discussing confidential matters with their seller-clients. However, in some New Mexico brokerage communities, it is customary to give buyers' brokers the privilege of presenting a buyer's offer. In what order are multiple offers presented to the seller for consideration? NMREC rules state that any and all offers received must be promptly presented to the seller for consideration, or the listing broker can face disciplinary action. Page 39. The seller must be permitted to view all offers to determine which offer is best. The formal acceptance or rejection must then be promptly communicated to the prospective buyer or buyer's broker. The broker needs to help the buyer understand that another offer may be presented while the seller is considering the first offer. No particular courtesies are extended to the person writing the first offer. There is no particular advantage to writing the first offer. Other offers arrive after the seller accepts an offer, should the subsequent offers be presented. The seller has the right to see offers that arrive. Even if an offer has been accepted, the seller is still bound to the accepted offer but may wish to view a later offer as a possible backup or secondary offer. However, many listing agreements limit the broker's duty to present offers after a contract has been signed. The seller cannot arbitrarily withdraw acceptance to sell to another party. Once the offer is accepted, what rights does the buyer have in the property? After a purchase agreement is signed and the buyer or buyer's agent is in receipt of the signed document, equitable title passes to the purchaser. At this point, although the buyer has an insurable interest in the property, most contracts place the insurance burden on the seller during the escrow period. The Vendor-Purchaser Risk Act places the risk of loss on the seller unless possession or legal title has transferred. What is meant by dual contracts and why are they illegal in New Mexico? The term dual contracts refers to two contracts from the same buyer on the same property. One of the offers is used to purchase the property, while the other is used to finance the property. The offer to purchase can be either written or just an oral arrangement, while the offer to finance is generally written. The true purchase price is known only between the contracting parties. The purpose of these contracts is to enable the buyer to obtain a larger loan than the true sale price, or to enable the buyer to qualify for a loan that the buyer otherwise could not obtain. Thus, the lender is deceived. In New Mexico, any person who participates in these actions could be found guilty of fraudulent practice and would be subject to disciplinary action. Closings. Under what conditions can the buyer request that some funds be withheld from the seller until all of the repairs are completed? Matters related to performance of the seller or the buyer are most often legal judgments, requiring the professional expertise of an attorney. If a buyer demands the withholding of funds as a matter of right and refuses to perform unless the demand